It's Friday evening and Priya is actually sitting in the parking lot of her office. She is actually scrolling two documents and staring at them continuously. The first document is her new offer letter that she recently got from this new company, and it has having around 30% of her salary hike plus a better company and a better LinkedIn resume also. The second document that she is actually scrolling again and again is her appointment letter that she actually signed with this current company around 4 years ago. And in her current appointment letter, she is actually scrolling and intensely reading one clause again and again, and it is related to her notice period clause. So basically, her appointment letter clearly says that if she at all plans to leave this job, then she needs to serve the 90 days of notice period. Otherwise, she cannot leave this current job. So regarding this, she actually approached her HR also that she plans to leave early, and her new company is asking to join within 30 days. So can we do anything about this clause of 90 days? To which her HR clearly replied that this 90 days of notice period is completely non-negotiable and she has to serve it at any cost. So now Priya is actually scared and she thinks that will she lose her dream job just because of this 90 days clause or not. Then the second question was, can this company really stop her from joining the new company? And the third thing she was actually worried was, if she plans to leave without serving this notice period, then what it will cost her legally. If you ever had these kind of questions in front of you, then you must not skip this video for sure, because what HR tells you and what the law actually says may not be the same always. So hi, my name is Akshay. I'm a lawyer. I have previously drafted these kind of documents for Indian startups. So I'm gonna answer these questions in this video in short. But first, let's clear the biggest myth and biggest misunderstanding that every employee has regarding this 90 days of notice period. So basically, every employee thinks that maybe this 90 days of notice period must have written in any law or in any specific labor law. But in reality, there is no such law that states or clearly states that employee has to serve these 90 days of notice period if that person at all plans to leave their current job. Then the main question arises, where exactly this 90 days of notice period has come from. So basically, whenever you join any company, then you will sign the appointment letter or the employment contract with the company. And company directly put this 90 days of notice period in your employment contract or the appointment letter. So this 90 days of notice period is actually only the contract between you and the company. So again, question arises, why companies put such a long 90 days of notice period in their employment contract? The answer is pretty simple. Replacing you will take lots of time. Hiring the right person will take time. Then finding that right person will also take lots of resources and time. So that's why they plan to put long notice period so that they can find the suitable replacement against you. But that certainly does not mean they can do whatever they want, because there are laws for your protection also, which we'll discuss right now. So now coming back to our original situation of Priya. So when she approached the HR regarding that she plans to leave within just 30 days of notice period, HR clearly told her that this is not possible and the notice period is at all non-negotiable. And if she still plans to leave within just 30 days, then she has to face the consequences. So the first is, we will withhold your relieving letter for sure. The second one is, we will deduct the amount from your final settlement. And lastly, if it's required, then we can take legal action against you also. To be honest, these kind of threats are enough for anyone to get scared. And Priya was actually scared in this situation, thinking that company will withhold her relieving letter or the company will deduct lots of amount from her final settlement. And even the company can file or may file a legal suit against her also. Now Priya was about to reject her new offer, but in this situation, legally, there are certain things that you can do, and I'm going to tell you in short. Now answering the core legal questions that Priya had in this situation. Firstly, can the company really force her to serve this 90 days of notice period or not? So legally speaking, employment contracts are personal service contracts, and the law cannot force you, or even the contract between you and the company cannot force you to stay in that company and do the job. Even if the company approaches the court regarding this situation, even the courts will not ask you to go and complete this 90 days of period. Therefore, can company really force her to complete this 90 days of notice period? The answer is absolutely not. So the second fear that Priya was facing was, can they deduct my salary or not? So the answer to that question is sometimes yes. And here is why. Priya's appointment letter had this buyout clause, and originally she was also planning to serve only for 30 days of notice period. And regarding the remaining 60 days, she was planning to buy out with her salary. So now the question is, can company directly cut her salary of 60 days or not, or like 2 months or not? Not necessarily. Because if the company is able to find her replacement within a really short period or within very short time, then company can take the reasonable compensation from Priya only. Since the actual loss company had during this period was very less, therefore company can ask for compensation from Priya but not the entire salary directly. And if the company cuts her whole salary of 2 months, then she can definitely legally challenge that in the court of law for sure. Now regarding the deduction, company can deduct her salary not exactly according to her CTC. Instead, company has to deduct her salary from her gross salary only. The reason is simple. CTC includes lots of things like your PF, insurance, bonuses, and sometimes these kind of amount or these kind of things never hit your bank account in reality. Therefore, whenever the company is cutting or deducting her salary, then they had to cut from your gross salary only. Now the most interesting part regarding the fear. Can the company really withhold my relieving letter or not? So this fear actually scares a lot of employee, because your relieving letter is one of the most important document if you are at all joining new company, and the missing relieving letter definitely can cause complication regarding your next employment with the another company, or even in the background checks it can create some kind of complication also. So now if you fulfill all the obligations of your appointment letter, then company is not definitely going to withhold your appointment letter at all. So if you have served the 90 days of notice period, or if you have offered to pay instead of this notice period, then there is no legal ground for the company to withhold your relieving letter in this situation. So most HRs also know about these legal things. That's why once the money is settled according to your appointment letter or the employment contract, then a relieving letter is definitely gonna follow. So now what actually Priya did in her situation. So first of all, she didn't panic. She did the math and she kept her sense. She was polite with the HR. Also, whatever the communication she did with the HR was through the email, so that everything is documented. And basically she served for the first 30 days, and the remaining 60 days she actually bought that with her salary. So she stayed professional with the company and HR, and within 3 days HR approved her exit from this company, and within a week she got her relieving letter from the company also. Since she acted according to her contract only, therefore company had nothing against her, and therefore she got clean exit from her previous company. So if you are facing this kind of situation, then do not get panic. Read your appointment letter, see if it has a buyout clause or not, and act according to your employment contract only. If you act according to it, most likely you will not fall for these kind of threats from this company or any company. If you have any legal query regarding your appointment letter or the employment contract, you can definitely comment down. I can definitely answer to those questions for sure. Until then, read before you sign, and I'll see you in the next video.